He set a gun on the dining table, and then he spoke. His wife heard it. She packed a bag, spent the night somewhere safe, and in the morning all she wanted was for someone to make sure he was still alive. She did everything right. So how did her phone call end with officers inside his house? His handguns in an evidence bag, no warrant and no crime. This is one bad night in Cranston, Rhode Island, and the question it dragged all the way to the Supreme Court of the United States. The question is not really his. It is yours. Can the police come into your home without a warrant simply to look after you? For decades across much of the country, the answer the courts gave was yes. This is the story of the man who made them answer it again, what he changed, and how much he left exactly where it was. It is August 2015 in a house in Cranston, and a marriage is under strain. An argument that will not cool. Edward Caniglia goes to the bedroom, comes back, and sets a handgun on the dining table. Then he says the thing the court record would later note in the flattest possible language. He asks his wife to shoot him. She does not scream or argue. She takes a bag, walks out the front door, and checks into a hotel. That was the entire incident. One sentence, and a woman who decided she came first. Nothing about that night made him a criminal. He was not charged. There was no raid, no standoff, no headline. It was a private crisis in a private home, and by morning the crisis had mostly passed. And then it is morning. The door is still closed. Everything that happens next is about that door. She cannot reach him by phone. So she calls the Cranston police, not 911, the non-emergency line, and asks them to do a welfare check. Go by the house. Make sure he is all right. Officers go. They find him alive on the porch talking. Whatever happened the night before, the man in front of them is calm. They want him evaluated. He agrees to go for a psychiatric evaluation on one condition, and he says it plainly. The officers are not to take his guns. They agree, he says. He leaves for the hospital by ambulance. And once he is gone, the officers go inside his home and take 2 handguns. No warrant, no emergency unfolding in front of them. The man they were worried about is already at the hospital, and they are in his house carrying out his firearms. His one condition was worth nothing. He had agreed to be evaluated only because he was told his guns would be left alone. He kept his half of that. The moment the ambulance doors closed, the other half was gone. He would later have to go to court just to get his own property back. 2 handguns that were lawfully his, held by the same officers he had asked to leave them alone. But the guns were the smaller fight. The real one was about the door itself and who gets to open it. And this is the whole case, stripped down. No one had arrested him. His home was not a crime scene. The police entered a private residence and seized property on their own authority to keep him safe from himself. They called it caretaking. For years in much of the country, this was simply legal. The settled law, applied by careful judges who believed they were being reasonable. The threat here does not look like malice. It looks like concern. So here is the question the incident actually poses. Not whether the police can arrest you in your home, and not whether they can come hunting for evidence. Whether they can cross your threshold without a warrant for the gentlest reason there is, to look after you and carry out what they find. For a long time, the answer was yes. Caniglia sued. He said the warrantless entry and the seizure violated the Fourth Amendment, the one that protects your persons, houses, papers, and effects against unreasonable searches and seizures. He lost. The federal district court in Rhode Island ruled against him. On appeal, the First Circuit Court of Appeals leaned on an idea called community caretaking and went further. It held that the community caretaking doctrine, whatever its origins, could reach inside a home. Warrantless entry, warrantless seizure allowed, so long as the police were caretaking rather than investigating. The police were not claiming this particular entry had been an emergency. Their theory was bigger and stranger. They argued that officers carry a general, free-floating power to look after the public, a caretaking role separate from fighting crime, and that this role can justify walking into a home without a warrant anytime they are acting for your good rather than against you. Peacekeeping, not law enforcing. Accept that, and for your own good becomes a key to any door, because almost any entry can be described that way. So where does community caretaking come from? Not from any statute. From a single Supreme Court case in 1973, see Cady versus Dombrowski. Cady was about a car. An off-duty officer had crashed and been taken to the hospital. His car was towed to a private lot, and other officers searched the trunk, looking for his service weapon so it would not fall into the wrong hands. The court allowed that search. It called the police work community caretaking functions, the routine, non-criminal business of clearing wrecks and securing hazards, totally divorced from investigating a crime. But Cady turned on something specific, a car on a public highway already in police custody. The opinion itself said it again and again, that a vehicle is not a house. Nearly 50 years later, some courts had quietly let that car lot logic drift through the front door of the American home. Before Caniglia, the courts had split. The 5th, 6th, 8th, and 9th circuits, along with the 1st, had let community caretaking reach inside a home. The 3rd and 7th had refused. Caniglia settled it against the home. The Supreme Court took the case to decide whether it belonged there. They heard argument on the 24th of March, 2021. 7 weeks later, on the 17th of May, the decision comes down. Justice Clarence Thomas writes for the court, and the court is unanimous. 9-0. The holding is narrow and it is exact. There is no freestanding community caretaking exception that lets the police enter your home without a warrant. Cady was a car in a lot, a home is not. As Justice Thomas puts it, what is reasonable for vehicles is different from what is reasonable for homes. The caretaking rationale does not cross that threshold, and the lower court was wrong to let it. For Edward Caniglia, already at the hospital by the time his handguns left the house, that meant the reason the police had given for going in was, in law, no reason at all. Thomas reaches for the oldest idea in this corner of the law. Quoting an earlier case, Florida versus Jardines, he writes that the very core of the Fourth Amendment's guarantee is the right of a man to retreat into his own home and there be free from unreasonable governmental intrusion. That line runs back through decades of decisions. The home is the center. Warrantless entry into it, the court has long held in Payton versus New York, is presumptively unreasonable. Presumptively. That one word is about to matter more than any other. Because a 9-0 headline is a trap. The court did not say the police can never enter your home without a warrant. It said that one specific excuse, community caretaking, does not open that door. The doors that were already open stayed open. A valid warrant, your consent, and exigent circumstances, the genuine emergency, including the need to rush in and help someone who is seriously hurt or about to be. If officers reasonably believe you are in danger inside, they can still come in. That was true before Caniglia, and it is still true now. Change one detail and the answer flips. That same phone call comes in, but this time, when the officers reach the porch, they hear a gunshot inside. A voice calling for help. A shape slumped against a window. Nothing in this decision keeps them out. That is a real emergency, judged by what a reasonable officer sees in the moment, and the law has always let them act on it. What the ruling forbids is the version that actually happened, the one where the person is already gone, the crisis is already over, and the entry gets justified after the fact by a general duty to be helpful. The line the court drew runs exactly between those two. 3 justices wrote separately, just to underline the point. The Chief Justice, joined by Justice Breyer, stressed that no warrant is needed to help a person who is seriously injured or threatened with injury. Justice Kavanaugh spelled out the ordinary cases the ruling leaves untouched. A suicidal person, a missing elderly neighbor, the emergencies where officers have to act now. And Justice Alito added a warning of his own that the court had not touched the hard questions waiting behind this one, the constitutionality of red flag gun removal laws, the seizures aimed at preventing a suicide. Those he wrote are for another day. And then there is the disposition itself. The court did not hand Edward Caniglia a final victory. It vacated the decision against him and sent the case back down, to be judged again under the correct rule, where the police were still free to argue that some other exception applied. A unanimous Supreme Court did not end his case. It corrected one wrong idea inside it. That is the honest size of what happened here. Not a wall around your home. One excuse taken off the table. Go back to the woman with the packed bag. She did the humane thing twice. She kept herself safe that night, in a hotel room that was not hers, and in the morning she asked the state to make sure the man she left was still breathing. She wasn't calling for a raid or reporting a crime. She had no way to know that a phone call to a non-emergency line would end with strangers carrying his guns out of a house she used to share. This is what the case is really about. There's no villain here, just a kindness that came through the door with a key. We're only here to help is the hardest reason to say no to. That is exactly why it needs a limit. So, the question from the very start, whether the police can enter your home without a warrant simply to look after you and take what they find. You have the court's answer now. After May 2021, the caretaking version of that excuse is gone. They cannot call it housekeeping and walk in. But the emergency door stands wide open, and it is a wide door. If they truly believe someone inside is about to be harmed, they can still cross the threshold and the courts will still let them. And the harder questions did not go away. They were simply postponed. Justice Alito named them out loud. When a state passes a red flag law and sends officers to take the guns of someone a judge has flagged as dangerous, is that a search the Fourth Amendment governs? And if so, how? And there is a harder one still. When the person the police fear for is not a stranger on a highway, but a neighbor they believe is about to end their own life, no one has yet settled how much they may do, or for how long. Caniglia answered none of that. It closed one worn-out excuse and left the genuinely difficult cases standing in line, waiting for the arguments that are being written right now, in courtrooms below the one that decided his. The 9 of them agreed on one narrow thing. What they left standing dwarfs it: the warrant, your consent, and every real emergency. If you started this thinking a welfare check could never reach past your own front door, and you see the line differently now, that is worth a like. It tells the channel to keep drawing these lines carefully.